Friends, good evening. On behalf of My Retired Life Foundation, we extend you to yet another exciting session of ours. And today's session is on a very, very important topic, and that's the writing of a will, whether it is for senior citizens or others. I mean, the writing of a will is very, very important issue. So we thought that we would have an uh, introductory, more practice-oriented session from a leading practitioner in the field on this particular topic. And incidentally, the counselor Amruta Lovekar, I was talking to her one day that can you suggest some good advocate who can talk to us on this particular subject and also be with us in constant touch with us from some other issues also. She referred Madam Kalyani Shukla's name, and that's how Madam Kalyani Shukla is over here. Now, we have already circulated the CV of Kalyani Shukla Madam, but let me also try to give very, very brief breakdown. She has gotten an exchequered career. She holds a very high degree of LLM degree. She has got about 4 decades of experience, legal experience. She has got a tremendous amount of expertise in the property law, the constitutional law, family law, and the practices and procedures of all types of the court practices. She has been as a consultant on the large number of the corporate, particularly let me mention one or two names over here: the K. Raheja Construction, Mumbai International Airport, Obera Realty. These are the 3 names which come to my mind where she has worked as a consultant. And most importantly, and that's of very interest to us, that since 2001 she has been extremely actively involved in various types of the social services. And when you look into our CV, you will see that the social services span starting from the orphanage to the children in the tribal areas, to the school education, to the physically and mentally disabled children, to the old age homes. I mean, say she has got a huge area of acting of social services. She has been doing, and she's also very active Lion International member, practitioner. And as you know, the Lion, along with Rotary, is one of the most leading institutions the world over, which has been doing a great humane service for the sake of the society. So on behalf of all of you, I once again welcome Kalyani ma'am and request her to please take over the session. Madam, the floor is open to you.
Namaste and good evening, everybody. Am I audible?
Yeah, you're audible, madam.
Okay. So I just want a quick question, whether all the participants over here, are they Hindus or there are different communities?
A majority are Hindus, but maybe 1 or 2 maybe other communities.
Okay, fine. Because what happens as far as this writing a will concerned, it varies from, if for a Hindu, there is a different set of laws. For Muslims, there is a different set of laws. And for others, there is a different set of laws. So that's why I just wanted to, but basically mostly are Hindus. So I will talk and I will just touch base on the different communities. If there is anybody, then he can one-to-one call me and I can guide him. Okay. So friends, I'm sure you all are all in that stage of life where you have acquired your properties, your whatever you have worked through your life and got something, some booty with yourself. So first thing, when you think what will happen after me to my things which are lying with me, that you have to prepare a will. Now, why you should make a will? That is very important. If you do not want your property to be distributed as per the provisions of personal law. So if you're a Hindu, it's under the Hindu Succession Act. If it's a Muslim, it's under the Mohammedan law. And if it's a Christian and Buddhist and Parsis, then it is under the Indian Succession Act. So number one is it will be distributed as per the provisions of law if there is no will. And secondly, to avoid disputes, because then after, if there is no will, there will be definitely disputes among the heirs. So one who is taking care of you, he will feel deprived. I took care of my parents for lifelong, and now I am only getting 1/4 or 1/3 of as per the provisions of law. So that is the reason why you should prepare a will. Now, who can make a will? Every person of a sound mind, not being a minor, may dispose of his property by way of will. So you have to be number one of sound mind, and you don't have to be minor, and majorly you should have properties which you want to dispose of. What is a will? It must be a written document and signed and witnessed. Three important things: it must be a written document, it must be signed by witnesses. So these first thing first, only your property which is in your name. Now what can you will? You can will movable properties, that is your gold, shares, bank accounts, and you can bequeath your immovable property. So that is your flats, land, everything. You cannot bequeath your body parts. You cannot write, okay, after my eyes should be donated, my skin should be donated, my liver should be donated, because you will be dead and gone. Will be open after 15 days. So you cannot bequeath. It doesn't make purpose of bequeathing your body parts. Only existing properties can be bequeathed. You cannot say like, okay, now I may be buying a property, or I may be buying shares, or I may be buying gold in next 5 years. All those what I'll be buying, I hereby give it to my ABC heir. Only future properties you cannot will. You have to have only existing properties. Now there are many things which you cannot will. You can't will everything. Tenancy rights. So if you're staying in a tenanted premises, like in Mumbai, if you see in South Mumbai, there are many tenanted premises where people are staying in that premises for years and years, and landlord is the actual owner and you are a tenant. So you become a tenant. That property you cannot bequeath because it is not your property. It belongs to a tenant. You are just staying there as a tenant over there. It belongs to a landlord, somebody else. Secondly, you cannot bequeath ancestral property. So if you have a ancestral property where you are a co-custodian or you have some undivided share in that you cannot bequeath, because that will go then again as per the Hindu Succession Act. The ancestral property is divided as per the chart laid down under the Hindu HUF Property Act. That is Hindu Undivided Family HUF. The entire ancestry property belongs to them, and that is how it is to be divided. So first, like I'll just repeat. Number one, it has to be a written document. It has to be signed. It has to be witnessed. You can bequeath only movable and immovable property. You cannot, and existing property. You cannot bequeath tenanted property, future properties, and ancestral properties. Now, when should you make a will? There is a general misconception that will needs to be made only at the time of death. No. At the time of death, you may die at the age of 50, or you may die at the age of 80. If you die at the age of 80, there are chances of the will being challenged, because the ones who are not getting or getting less share, they might say that she was not in a proper favor wife, she was coerced by one of the family members, and that is why she willed it to, or he willed it to her, XYZ. So anytime the day you decide, no, I have got enough property and I need to give it to my children, and you have to give it to somebody when you go, your children or a trust or some charity, because you cannot take anything with you. So this is now is the time when you should make a will. That is, and when you are in senses, you are agile, you are in a proper frame of mind, these things you should make a will. The earlier you make the will, there is a chances of it being suspicious or the genuines are less. So the earlier you make, it is better for you. Now, how to make a will? There is a lot of misconception. What I'm going to tell is the correct way. A will can be written on any paper. It doesn't say you have to put in a green paper or lawyer's paper or X paper or Y paper. Any paper, it can be made. It did not be made. It is not to be made on a stamp paper. There is general misconception that stamp paper pe likho, stamp paper pe likho. No, plain paper, it has to be written in. It can be written in any language. It can be written in your mother tongue, your English, whatever language you are comfortable with, you can write in that language. It is not compulsory that it should be in English. It is not compulsory that only a lawyer should prepare a will. You yourself can prepare a will. You have to write it. You have to write your name, your age, your address. Then you write what are the names of your heirs, list of properties, and which heir what property you want to give. First thing, your will has to be there has to be clarity of thought when you write. You should think through properly before you're writing your will. Because if you have, say, 4 flats and you have to give to 2 people, you have to write their names. Okay, I have 4 flats, and from that A flat I'm giving to B, second flat I'm giving to B. Whatever the names of your children, or whomever you want to give, you have to write the exact name. There is no need to use technical language. Clarity is very important, that when I read a will, I should immediately come to know, okay, this lady or this gentleman who has expired, this was his wish and this is what he wants to give. Number one, you shouldn't be conditional bequest. Like many will come and ask me, I want to give it to my son, I want to give it to my wife, but then my wife should give it to my son. So can I write, I'm giving it to my wife, but then she should give it to her or my son? No. They cannot be conditional will. It is ambiguity. It is open to challenge. Your wife will not get anything. Then son will claim, no, my father has given to me. So you only have right to live in that. You don't have right to dispose of the property. So there shouldn't be a conditional will. So again, I'll repeat. It has to be a written document. Only you can give movable and immovable property. You cannot bequeath future properties and tenancy property and HUF property. It has to be a written document, witnessed and signed. It can be written in any paper, in any language you want, as long as there is a clarity of whom you want to give what. That is very important. There is no need for any technical term, legal term, nothing. Simple language. What you want to give, what your intentions are there, that should be written properly. It should be one single document. Please remember, you can't have 10 copies floating around. If you have 10 copies floating around, there is a chances of it being challenged, misused, anything. So one single document, it should be. Now, essential, what are the main requirements of the will? So now you have written a will, you have to sign it. You have to sign that will. It has to be witnessed by minimum 2 or more witnesses. The person who are witnesses, they have to see you signing that particular document. So the witnesses, you have to sign before the witnesses. The witnesses, you cannot sign it prior and then, okay, whoever is your witness, okay, you come in now, okay, now I have signed this document, you please witness this. That is not the case. You have to sign before the witness. Now, who can be a witness? Please understand, in a will, the only important person is the witness. Because you have written your will, your witness has witnessed that will, and you are dead and gone. You are dead and gone, your will is open. Now, who are the 2 people who are going to corroborate? Okay, no, this is what the deceased had intentions of giving it, is your 2 witnesses. So, witness must be an adult, he must be a sound mind, and he must be a trustworthy person. He should not be a person who will go and disclose to the beneficiaries or to your heirs, your mother or father or somebody has made a will and this he has written. He should be a trustworthy person. Beneficiary cannot be witness. Like if you're giving it to your son or your daughter or your grandchild or anybody, they cannot be a witness. A friend, a trusted person should be he can be a family member, anybody he can be, but he should be a trustworthy person. One witness should be a doctor. It is not compulsory, but it is advisable. Why a doctor? because a doctor will corroborate, can know when she signed the will or when he signed the will, they were of agile mind, they were in proper frame of mind, and it was not that they were senile or they were in a different, I mean, they were unwell or something. So the doctor has to put his rubber stamp and his registration number. So these two people are very important. The witness's name, address, phone number, doctor who is a witness, his name, address, phone number, and registration number. This should be affixed on the document, which is your bill. It is advisable to always have a younger person as a witness. So today at the age of 60, if I'm making a will and my witness is also of age of 60, there is a bright chances of he or she predeceasing me. So then your witness goes away. So then you'll have to again make a new will because your witness is already gone and you need to have two witnesses. So take a person who is younger than you, say 10, 15 years younger than you, who is a family friend or somebody. So at least he will outlive you because he is the one who is going to corroborate and he is the one who is going to conform to the court of law. No, these are the intention and this is why, how they have to, they wanted their property to be distributed. So like I have said, two important things: written document, no future property, no tenanted property, no HUF. It can be written in any language, in your own handwriting. But only clarity of thought has to be there and there have to be witness. Now, registration of the will. There is a misconception that will should be registered. Registration is not compulsory, but it is advisable. Registration doesn't give a special sanctity to the will. It is only advisable that you register so that the chances of challenge are reduced. So if a will is registered, you have to deposit with the registrar. The registrar is a person where you generally register your flat agreements, flat purchase agreement, or your live-in license agreement. That is a register where you register the will. Now, one thing is important: if you register a will and tomorrow you decide after 2 years or 5 years, I want to change the will, then the second document also needs to be registered, because between a plain non-registered will and a registered will prevail. So if you have registered a document, you have to register a change document also. The change document nomenclature is called a codicil. The first document which you prepare is called a will. Any change document you prepare is called a codicil. So if when you register, remember this aspect. This is very important. Then I will go back to again preservation and safeguards. I have told you it has to be a written document, clarity of thought. It has to be signed by two witnesses. You have prepared a will and you are done with it. You have to sign before the witnesses. The witnesses also have to put their sign. How you are going to preserve that will? Now you have prepared a document, you have prepared your will, how you are going to preserve that will? You have to keep it in a sealed envelope. Don't put it in a plastic paper, because there have been instances that the ink with which you have written or you have typed gets stuck to the plastic. So then that will is not acceptable in court of law. It has to be either you put two butter papers in between. If it's 2-3 pages, then put a butter paper in between and preserve it in a sealed envelope. You can keep it with a lawyer. You can keep it with one of the witnesses who is your trustworthy person. You can keep it in your locker, or you can keep it with any confidant. If not witnesses, with anybody you can keep that will. But ensure that when the right time comes, you have to disclose that I have made a will and the will is lying with Mr. So-and-so, or it is lying in my locker, or it is lying with my lawyer, or it is lying with you. You have to inform, because if you prepare a will and if your heirs do not know that there is a will prepared, they will not the possibility is that the person with whom the will is kept, he may not know, he may be traveling somewhere and he may not know anything. It may be too late for him to inform, or if it is kept in the locker, then they may not be able to open the locker. So it is advisable that you inform somebody and go, okay, no, I have made a will and it is kept with Mr. So and so, and it is to be opened on my death. So I have told you how to preserve the will and where to keep the will. Number one is, if you want to ensure that your will is not challenged or it is not open to challenge, when you are preparing a will, you can take a videograph on your phone, mobile phone, whoever the witnesses and all are there with you when you're preparing will. Take a videograph of that particular process which you're going through. You can read out, okay, these are my properties and this is what I'm giving. And you can, when you're signing, somebody may take that entire video of your entire exercise of will. If you take out that video and also keep it with the sealed envelope, the authenticity and the chances of it being challenged will be reduced, because there'll be many corroborations to show that no, this is the will you have prepared and this is how. There won't be open to forgery. Like I said earlier, you should have only one copy. Don't have 10 copies. It will be open to forgery. It will be open to misuse. It will be open to duplication, and there will be your purpose of preparing a will be not served. Now you prepared a will after 5 years. You thought, no, my daughter is not treating me properly. I don't want to give her. I want to give it to somebody else. If you have one document, just tear it and throw it away, burn it out. My advice is burn it. If you have registered the will, then you'll have to prepare another document and again go and register it. If you don't register it, then that registered will prevail. So burn it off if you want to change your will. That is why I always have one copy, and don't and when you burn it off, when you're tearing it off, you have to tell your witnesses, okay, this will you had witnessed it and I'm tearing it off. I want to make a fresh will. The same people can be your witness. That you don't worry. You can bring same people as a witness, or you can bring somebody else also as a witness. But you please inform your witness that the will which you had witnessed, I have torn it off. I'm making a fresh will and I'm taking somebody else a witness. So can you also only be our witness? If will is lost, it is presumed to be revoked. You made a will, you forgot where you made and where you kept it. So now it is presumed to be revoked. But if you made a fresh will and that will is again found, the date which you put, the latest date is important. So when you make a will, your name, your age, your address, your date, that is why I said these things, the latest date will prevail. As far as registered and unregistered, registered will prevail. As far as date is concerned, the latest will prevail. So please ensure that you keep it in a proper place and you don't make any mistakes. Now, there is a executor. You must have heard a word of executor of the will. So if you have only one flat, only some 10 grand, some 20 tolas of gold and some 10-15 shares and 2 bank accounts, there is no need to prepare, no need to make an executor. Executor is a person where you mention the will, the executor will be a trustworthy person who will ensure that the amount, that what you have written in your will is distributed as per your requirements mentioned in the will. So executor can be one of your trustworthy persons. He will manage, after your death, he will manage your estate and he will accordingly distribute your property to the beneficiaries under the will. One of the beneficiary can also be an executor. So if you have 4 sons, you can make one of them as he is the executor and he will ensure that the way properties are distributed. So he can also be an executor. So beneficiary can be executor, a confidant can also be your executor. ideally the executor is appointed when you have vast property. That is like you have some 10, 15 flats at Pan India. You have some 1,000, 5,000 shares, some 3, 4 crore shares. You have 4, 5 bank accounts. So you want to, and you want to ensure that all your heirs get their share properly. Then you appoint an executor, because the executor, he is going to manage the estate from your money only. He's not going to shell out the proper money from his pocket, because once a will is formed, there are many legal obligations which they have to undertake in respect of the will, which I will tell you later on. So he will ensure he will ensure all these things. He will spend from your this thing only. He's not going to spend from his pocket to ensure everything is done properly. So executor is not compulsory. It is advisable when you have a lot of property and you want to give some money to charity, you want to give to your friends, you want to give to your family, you want to give to this. So that is why executor is important. Next, I will registration. I have already told you all, it is not compulsory, but it is advisable. And if you register, you will have to re-register it if you change the will. Preservation also, I have told you, you have to preserve it in a paper and in a sealed envelope, and you have to inform. You want to revocation, if you want to cancel your will, you'll have to burn it, tear it, and prepare a fresh will. Now, advantages of making a will. Many people ask, I've got only one son or one daughter, do I need to still prepare a will? Then the answer is yes. Because our legal system is so tedious that for your child to prove that he is the only heir, he'll have to give n number of documents. So if he has a will or she has a will, that one document will suffice for her to produce before everyone and get the legatee or get the benefit, all the properties or all the bank accounts transferred in her name, or open the bank locker or whatever it is. That is why it is advisable to prepare a will. Otherwise, and if there are many heirs, the distribution will take long time, Then they'll have to file, even if, so that is why it is advisable that you prepare a will for proper and correct distribution of the assets, so that your heirs do not fight amongst themselves and avoid legal issues which they will face in distributing. It is advisable to make make a will. Then I will tell you is wills and nomination. Like there is a question where people say, I have nominated in my society share certificate, I have nominated my son's name, so he only will get it. No, legally nominee is not the heir of or not the owner of that particular asset. He is holding that particular asset only as a trustee for and on behalf of all the heirs all the heirs of the deceased. If you have only one child and if you have only one flat, now and you make him a nominee, yes, he will get it, but still he will have to prove that yes, he is the only heir. And if you have 4, 5 heirs and you are putting nominee of Mr. A, then in your will you have to ensure that this particular flat you will it to Mr. A only and not to Mr. B, then there will be again confusion. So if your son's name is Mahesh and Suresh, and you want to give with the nomination in one flat is Mahesh and one flat is Suresh, in your will you should mention that Mahesh will get this flat and Suresh will get that flat. Otherwise, there will be a confusion again at the time of actually when the bill is probated and when they go to the authorities, this is the will and the flat should be given to me. So always ensure that whoever is a nominee has to be his name should be there in the inheritance. But simpliciter nomination doesn't give him a right to become a owner of that flat. So Please don't be under this misconception. In case of nomination and will will prevail, nomination will not be given importance. So it is advisable to have same person as nominee as a will. Now, what is a probate? Now you have prepared a will or you have not prepared a will and you have dead and gone. So if you are dead and gone, what happens? What will your heirs do? If you have prepared a will, they will file in the court of law for probating it. Probate is a document whereby the court certifies that yes, this is the will of the deceased and this is what he has wanting under his will, his assets should be distributed. So that your heirs will have to file in the court of law. Now, this probate, if your properties are in Mumbai, Calcutta and Chennai, please, then only they will have to go for probate. If they are in any other property in other states, then there is no provision for probate. So this is a small distinct differentiation as far as these three cities are concerned. Mumbai, Calcutta, Chennai, your property is in these cities amongst other cities, then you will have to file a probate. But if you don't have in these cities your property, then no need for probate. That assets among the heirs will be distributed as per the will. If you want to bequeath to a trust, if you want to bequeath to your children, you have to give it to some charity. In your will, please be very clear which is the charity, where is it situated, what does the charity do. All those entire data should be written in that particular, otherwise it will go waste and there will be a fight among those far off heirs among your will and they will, it will not go to the person whom you want. Minor. If you will to a minor, you can, I want to give to my grandson. Okay. So if you want to give it to your grandson, you can give it to your grandson, but please understand that his parents are the natural guardian and natural guardian of that particular child. So till he doesn't attain the age of 18, the parents will, his parents, mother or father will be natural guardian, they will take care of his property. And then later on when he attains 18-year-old, he may, they will dispose of the property. So, but please understand, they may dispose of, they may not dispose of, but please understand there is a possibility that since their parents are natural guardians of the child, there is a possibility that they may, when he's a child only, make an application to the court saying that this particular property we are disposing of in the interest of that grandchild or that small child. So there is a possibility they may dispose of. That court will then ask them that you deposit that sale proceeds in a FD or something. So these possibilities are also, this also can happen. So like I said, if there is no will, if there is a will, they will apply for probate. If there is no will, they'll apply for letters of administration, wherein all the heirs will have to file an application in the court of law and the assets will be distributed as per the Hindu law or Muslim law or special Hindu or Indian Succession Act, whichever community or religion they follow. So these are the main aspects of a will. I have told you consequences of will. What happens? There will be a fight amongst your heirs. So I will just recap everything. It has to be a written document. It has to be signed by witnesses. It can be on any paper. No legal lawyer is required. No paper, no special paper is required. It can be handwritten. It can be typed, whatever you want. It has, you cannot bequeath future properties, HUF properties, and tenanted properties. You can bequeath only your movables and immovables and existing properties. Witness is the most important person in your will. So please ensure your witnesses are 2 witnesses. You can go for 3 also, but they should be younger than you because they will corroborate, they will confirm the contents of your will. Even if you have only child, you should make a will. Registration is not compulsory. Proper preservation is compulsory. Ensure that it is properly preserved. And once you have prepared a will, your heirs will take care of it properly. You don't have to worry. Domination does not entitle a person the right on the property. He is only acting as a trustee of that particular property. So I think I have covered everything, what is there in the will. And if you want to change your will, tear off that will. Burn it off, not tear off, burn off that will and prepare a fresh will. If it is a registered will, then you'll have to register the second will also. Otherwise, the one which is registered will prevail. And don't make copies of the will. It should be one single document. Clarity of thought should be there. This is it. Any questions? I'm open to the forum. Please ask away.
Madam, good evening.
Good evening.
I'm R.K. Modi. Suppose
Yeah.
there is no will
Yeah.
and the person dies. Wife is alive and siblings are alive. So this property, who will be the owner of that property?
Or if you have one wife and if you have two siblings, then it will be divided amongst three of them, 1/3, 1/3, 1/3.
Then second question is on probate.
Yeah.
You told that in Bombay probate has to be done.
It's compulsory.
Compulsory.
Yeah.
What about Navi Mumbai?
Navi Mumbai is also there. Even Navi Mumbai. If
Thank you,
it
madam.
comes under the Mumbai jurisdiction. Your jurisdiction is Thane or it is city of Mumbai?
It is Thane, madam.
Then not probate is not required.
Can I ask, ma'am?
Yes, please continue.
I am Nafisa. I would
Yeah.
like to know Mohammedan law about.
Mohammedan law, please.
yeah.
It is very stringent.
Thank you.
It is very onerous. And I will tell you about Mohammedan law. You follow the Shariat law. You can bequeath only 1/3 of your property under the Mohammedan law. You can 2/3 of the property is to be distributed as per the chart laid down in Mohammedan law. So if you want to bequeath anybody, you please in your lifetime only you transfer that property in that XYZ's person name. You cannot bequeath more than 1/3. So if you have the 1/3 means value of your property. If you have property worth 5 lakhs, then you can bequeath only the value which is of 1.25, 1,25,000. So this is very important for Mohammedans. So generally you transfer it in their name, either you gift it or you transfer by the property in whomever you want to give in their name. Yes, tell me. This is very important.
Yeah, thank you so much.
Yeah.
Kalyani,
If
madam, I have
madam-
got two questions. One question is, can what do you call the witness be executor?
Yes.
Witness can be an executor. At the second question, that if I have got let's say MOL property, and I've got two siblings, can I jointly? Can I jointly give it to bequeath them, or what is the way then?
You're right. Okay, both have got equal rights in the property. Because that's it. Both are entitled to equal. Both are entitled to equally share the property amongst themselves. But one line.
Oh, okay. Thank you. Yeah. Further
Hello.
questions, please.
Hello,
Yeah.
ma'am.
Yes. Good evening.
Good evening. I'm G.S. Saluja.
Yeah. Tell me.
Where the Sikh community is covered by which law?
Sorry, Sikh
Sikh
community is covered by. Just give me a moment. I think Indian Succession Act.
Yeah,
Hello.
ma'am, can I ask you a question?
Yes.
My name is Sharad Umarji.
Yes.
if you own a property today,
Hmm.
in your it is a joint property with your wife,
Hmm.
can both make a will, a joint will to be distributed amongst your kids? Later part, can the said will can be changed if and only one person is surviving of the two?
So I would advise you not to make a joint will, because what will happen? You made a joint will today that this property is owned by me and my wife. We both own this property jointly, and we want to give it to my son, Mr. Suresh. That is what you will write in your will.
Right.
So pending, you made a will and your wife died.
Yeah.
What happens? The joint property, both are owning half.
Correct.
But as far as you're concerned, you're still living and your wife is dead. Then you'll have to make a fresh will, because then what will happen? Your son will become owner of half the property, because wife, her share, she has bequeathed to him, and you will become the owner of half the property. So
Right.
ideally, when a property is joint, no, you bequeath to each other. You say, okay, either I give my share to my wife, and vice versa, wife gives the share to the husband. So when either of them dies, the living person becomes the owner of that property, and then he in turn, then when he wants to bequeath, he can give it to the son or daughter, whomever she wants to give.
Okay. Thank you.
Yeah.
Good evening, madam.
Good evening.
Yeah, there is a question already in the chat box. I'm reading the same question because even my query is the same. If the beneficiary is different from nominee in residential property or bank accounts, which supersedes?
Beneficiary will supersede.
Okay.
The will supersede the nomination.
So when we have the FDs and all in the bank, we generally give the nomination. So it's important.
I know. But then that is why I said, okay, just do whatever, if in your bank account, if the nomination is of your son Suresh, and then you in your will also you write, okay, this bank account I give it to all the proceeds which are there in bank account, I give it to Suresh. That is why it is advisable to have will prevail over nomination. That
Okay.
you take.
Thank you so much.
Yes.
Madam, same law applies to Mohammedan law about the bank FDs, or there also it should be 1/3.
Whatever your assets are there, 1/3 only can be bequeathed. So that is why then you don't prepare a will, you directly give it to whomever you want. Because your Mohammedan law is very onerous. It is advisable you give it, if your intentions are to give it to your son or to your daughter, from inception only you give it to them.
Fine. Thank you.
Anybody?
Any other question? Anybody else will ask any question? Anybody?
I have one last question.
Yes, please.
If there is no nominee written and the person, there is no other siblings and all, then what happens? You have not written
You have not, so your question is, you have property, you have not written any nomination, you don't have any children.
Right. Or I have children, but I have not yet nominated them. I write it to somebody else.
So please understand, nomination you may write, you may not write, that is your prerogative. If you have not prepared a will, then all your heirs will get as per the personal law to which you belong. If you have prepared a will, then it will go to that person whom you wish to give after your death.
Oh, thank you.
Yeah.
Hello, can I
Yes.
question?
Yes,
Yep.
please.
Yeah, I'm Chetan Deshmukh here.
Yeah,
In fact, actually, I am having some residential properties in which me and my son both are jointly been there in the property.
okay.
So my question is actually, do I need to prepare a will for my wife? If or in that case, even my son has to sign the will, or how is it?
So you have a
Yes.
flat which is owned by you and your son jointly.
Yeah,
So what happens if you don't prepare a will?
yeah,
I tell you, I'll give you consequences if you don't prepare a will and you're dead and gone. So
Yeah.
that 50% which you are owning will be bequeathed to your wife and your son equally. So your wife
Yeah.
will get 1/4 and your son will get 1/4. But if you
Correct.
prepare a will, okay,
Yeah.
my half share I give it to my wife, then your son will not get anything. Your wife only will get, then your wife and your son will become joint owners.
Okay.
So
So in
now
that case, I need to prepare a will for myself, means for my wife.
for your wife, yes, advisable, advisable. Yeah, because
Thank you, ma'am.
1/4 is too small a share for her to then, agitate. Or,
Very true.
yeah.
Very
Okay.
true. Thank you.
Yeah.
Madam, Jyoti
Bola.
here. Hello. Jyoti Keswani here. One flat was there in the joint name of my 2 brothers and 1 sister-in-law. So my brother, now he was not married and he died 6-7 years back. Now brother and sister-in-law are there, but then society is not transferring in their name. They are saying that they need succession certificate.
Yes. Yes,
But
because your brother who has died intestate. So so if his share will be divided among all his siblings, means your sisters.
We are reminded.
Then they'll have to file in the court of law. It's a small procedure. It will within 6 months he'll get the succession certificate, wherein you all have to give affidavit. Okay, fine. I don't want to claim any share in my deceased brother's property. Ideally, the society should take your indemnity and from all the heirs and
They are not ready to give, and for succession certificate, minimum expenditure is 1,50,000.
Yeah, because on the value of the flat, you have to pay court fees. Yes, I agree. Yes, yes.
So society, we are telling we are ready to give you indemnity bond, and one brother and sister, we are ready to, only we 2 are there. So we are ready to give that. We don't want to claim any share in that property. So society should be ready to
no, but now what happened? No, there are so many claimants coming, and societies are being more cautious because the laws have become very stringent. So that is why, yes, I understand you have to take a succession certificate.
Okay, thank you.
Madam, if we have written the nomination and we don't put it on the will, then what happens?
Means you have not prepared a will, or you have prepared?
No, if we prepare the will and we have not mentioned the bank, suppose FD nominee's name, if we don't mention in the will, so will the beneficiary?
I'll tell you what will happen. So in the FD, there is no nomination, or there is a nomination?
There is a nomination, but
so in the FD, yeah, okay. So in the FD, there is a nomination of your daughter Sunita, and in the will, the name is that this FD will go to Kavita or to Suresh. Then it will go to Kavita or Suresh, and not to Sunita, whose nomination is there.
No, but if we don't mention in the will, and only nomination is there in the bank.
No, but I mean, if you have a will, then why you don't want to mention in the will?
Maybe by mistake we have not mentioned. Oversight.
Oversight, then for that, if there is a will, then that particular FD will be divided among, that amount will be divided among all the heirs. It will be presumed that for that FD, the intentions were not shown by the particular deceased, and so that money, she will be holding that money for and on behalf. She will get the money. It's not that she will not get the money, but there is a chances that the other siblings might claim for this, as far as this is concerned, since there is no will, nothing is mentioned, so we all should get equal right in that amount which is there of FD. So she will get the or the others may say, bank may say, see, my mother has prepared a will, she has not put this nomination, so then the bank will say, okay, bring a succession certificate. So see, if the amount is very small, no, you won't have any problem. But if the amount is in crores, then you will have a problem.
Oh, thank you.
Yeah.
Madam. We'll take any last question.
Yeah, madam.
Yeah.
I have a question, madam.
Please go.
Yeah, I want to know if I can gift instead of will. So what is?
Yes, you can gift. You can gift it. But ideally, what happens, if you today you say gifted to your son your flat,
Yeah.
There is a chances of that after receiving the gift, the child may misbehave with you, and they may take advantage of now. Okay, now mother is dependent on me, or father is dependent on me. So there are chances that they may misuse or misbehave with you, and you might regret gifting it. So it is advisable that you will it instead of gifting it.
And in gift, I have to pay something to the government.
Yes, you have to pay stamp duty.
Approximate.
It is on the value of the property, if I'm not mistaken.
Then no need of making a will if I give.
Yeah.
Then
But advisable not to make a gift.
Oh, thank
I think I also agree that we should not gift a property and create
Yeah.
a problem for us
Yeah.
as senior citizens, because there are hundreds of cases which we handle every day almost, where this is a problem. The people have gifted the property and then there is a consequent problem actually.
So
Ulta
now
problem.
courts, yeah, so there are
I know.
there are judgments where court has
Yeah,
cancelled the
you can
gift,
take back.
but then you'll have to go
Yeah.
to the court of law, and that will be
Yeah,
bitter. It'll be bitter fight,
Yeah,
and you wouldn't want to fight with your own children, in your
Yeah.
last stages of life.
Agreed.
Yeah.
So I think if there is no other question, I think it was an excellent and outstanding session to say the least. So
Thank
on
you,
behalf
thank
of all of
Sir,
us,
I think you can share the contact details of
very much.
Madam Shukla.
You can share my contact details. They
We,
can.
we will do it.
I will
Please,
advise
please,
them.
please.
Any-
Thank you.
Okay, thank you.
We will
Thanks.
do it. We will do it as then somebody requests, they can ask me and we will pass it on. So thank
Yeah.
you, madam, for this excellent
Yeah.
session, and we
Thank
look forward to
you.
your further
Anytime.
support.
Anytime.
Many
Thank you so
many
much.
times. We're very
Thank you.
grateful.
Thank you.
Thank you.
Thank you, madam.
Bye.
Thank
Bye.
you.
Very much,
Thank
madam.